Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. It's Qanon Shaman Guy. Qanon Shaman Guy is in the news. He is seeking to void his guilty plea. He pled guilty. He pled guilty and he was sentenced to 41 months in jail, which is, 3 years and change, so it's pretty significant. And he is represented by a new attorney, John Pierce, who represented Kyle Rittenhouse for a little while, who, John Pierce is not exactly my first choice of a lawyer, to be honest, any more than like Lynn Wood or Rudy Giuliani. John Pierce is kind of, not the person I'd recommend, although he might be the perfect attorney for this client, but whatever. So we're trying to appeal the sentence. So this appeal comes the day after the federal judge accepted his plea and sentenced him. So, there's that. So he's going to try to appeal he's appealing both the judgment and the sentence. So he wants to appeal the judgment of guilty in response to a guilty plea, and he wants to object to the sentence. Okay, so let's talk a little bit about what he did according to him, right? Because we're going to now review two documents. This will be the longest story of our day because we're actually going to do some legal analysis on this one. So in order to plead guilty in the federal system, it is almost ubiquitous that they're going to get you to sign off on a statement of facts. Like, here are the facts, you're agreeing to these facts, and also a plea deal, right? So you're signing off on the facts. These are facts. I agree to those facts. And you're also agreeing to the plea deal. So we can cover those things, right? We can cover those things and see, what did he agree to? What is the plea deal? Great, let's do that. All right, so here's the statement in support of the guilty plea. So this is prepared by the U.S. attorney, but he signs off on it. He signs off on it to say, yes, I agree to these things. So the defendant agrees to plead guilty and enter a guilty plea on count 2. The penalty for this offense, they stated right up front, the penalty for this offense is a term not greater than 20 years, a fine not to exceed $1 million, a term of supervised release up to 3 years, and a special assessment of $100. They spell it right out for you. Like here, they put it right up front. Here's the possible penalty. The elements of the charged offense. The defendant corruptly obstructed, influenced, or impeded, or attempted to do an official proceeding. A proceeding before Congress is an official proceeding pursuant to 18 U.S.C. 1515, which, So, you tried to corruptly, with corrupt motive, obstruct, influence, or impede. The reason why it says corruptly, by the way, is because you can non-corruptly influence. That would be like if you're lobbying Congress or just giving testimony to Congress, right? You're trying to influence them, but not corruptly. So that's why the word corruptly is in there, because there are lawful methods of influencing an official proceeding. So that's why the word corruptly is in there, to have that additional thing. Okay. And the official proceeding is Congress. That's great. So the government respectfully submits the following statement of the offense in support of the guilty plea by the defendant, Jacob Chansley. If this case were to go to trial, the government would be able to prove the following facts beyond a reasonable doubt. So they're laying it out. What are the facts? The U.S. Capitol is secured 24 hours a day by Capitol Police. Restrictions around the U.S. Capitol include permanent and temporary security barriers and posts maintained by Capitol Police. Only authorized personnel with appropriate identification are allowed inside the U.S. Capitol. On January 6th, the exterior plaza was closed to members of the public. That's true. We saw huge gates around it with many, many signs. On January 6th, there was a joint session in Congress to certify the vote count. At this point, again, for the YouTube people, I'd like to point out that in describing this, I am in no way encouraging or suggesting that this is a good idea. I can't believe I have to explain this, but apparently I do. In describing this, I am not saying that you should go do these things. These are bad things to do. Do not do these things. If you do these things, you may get these penalties. I can't believe I have to explain this to YouTube. Unbelievable. As these proceedings continue in both House and Senate, with Vice President Pence providing, a large crowd gathering over the U.S. Capitol, By 1:50 p.m., the defendant, Jacob Chansley, was among the members of the crowd at the police line, where the U.S. Capitol Police and Metropolitan Police were standing behind the line. Defendant was dressed in a Viking hat with the fur and horns, was shirtless, wearing red, white, blue face paint, and carrying an American flag tied to a pole with a sharp object at the tip and a bullhorn. At 2 p.m., certain individuals in the crowd forced their way up, through, and over the barricades. The crowd was not authorized to enter. The defendant was among this crowd that passed the police line, entering the scaffolding. Defendant and others pushed past the police line at top of the scaffolding and entered the Upper West Terrace. At this time, certification proceedings were still underway. The exterior doors and windows were locked or secured. Members of the Capitol Police attempted to maintain order and keep the crowd from entering. However, after 2 p.m., individuals in the crowd forced their way into U.S. Capitol, including by breaking windows and assaulting members of law enforcement. This riot resulted in substantial damage and requiring the expenditure of more than $1.4 million to repair. So that's a lot of damage, which, I believe. That sounds very plausible. Because some of the stuff in the Capitol is fairly ornate, so depending on what you damage, yeah. Defendant was with this mob that went into the Senate side. Other members of the crowd broke in. Shortly thereafter, the members of they did evacuate the chamber. Defendant and other rioters ascended the stairs to the second floor. In clearing on the second floor, defendant and other rioters were met by a line of U.S. police officers, instructing them to leave. Defendant challenged the police officer, KR, to be let pass, also ultimately using his bullhorn to rile up the crowd and demand lawmakers be brought out. So he is fairly literally leading the charge. Instead of obeying these instructions, defendant traversed another staircase. At 2:52, defendant entered the gallery of the Senate alone. The defendant then proceeded to scream obscenities into the gallery while other rioters filled the floor. Defendant left the gallery and proceeded down a staircase in an attempt to gain entry. He therefore once again encountered Officer KR, who once again asked him to leave. Defendant insisted that others were all around the Senate floor and he was going to join them. Officer KR then followed the defendant onto the Senate floor. Defendant then scaled the Senate dais, taking the seat Vice President Mike Pence had occupied less than an hour before. The defendant proceeded to take pictures of himself on the dais and refused to vacate the seat when Officer KR, the lone law enforcement officer at the time, asked him to do so. Instead, the defendant said Mike Pence is an effing traitor and wrote a note on an available piece of paper saying it's only a matter of time, justice is coming. Well, you were right, my friend. You were right. As Officer KR again asked the defendant vacate the seat, the defendant remained, calling up other rioters to the dais and leading them into an incantation. You should not do these things, which includes giving opportunity to allow us to send message to all the tyrants, communists, and globalists that our nation, not theirs, will not allow America, the American way of the United States, to go down. Defendant went on to say, thank you for allowing the United States of America to be reborn. Thank you for allowing us to get rid of the communists, the globalists, and traitors within our government. Yeah. Eureka Hope says, what a threat. He wasn't charged with being a threat, Eureka. Please pay attention. That's why we're doing the legal analysis. Was he charged with being a threat? No. Well, he might have been, but that's not what he pled guilty to. So what he's charged with is kind of irrelevant at this point, because only what he pled guilty to is a conviction. He pled guilty to obstructing an official proceeding. So you say, what a threat. And I say, well, I don't care, because he was charged with obstructing an official proceeding. I think these recitation of facts lay out a pretty good case that he was, obstructing an official proceeding, which is the thing that he said that he did as part of his plea agreement. Yeah. As a result of these dangerous proceedings, Congress could not resume until every occupant left. In the days after, they gave media interviews to which the defendant said, the defendant actions halted normal functioning of Congress, including the certification. And this is signed, of course, by the U.S. attorney, and then most notably signed by the defendant, right? This is where the critical part comes of this exercise. This is where he signs it, saying, yes, that happened. I have read this factual proffer. A proffer, by the way, is just a very fancy term for like an offer. It's also sometimes called an offer of proof. It's basically, here's what I would be offering. Here's what I would say. So I've read this factual proffer. I've read what you would be presenting. I understand it and agree it's true and accurate. So he agrees to it. He agrees to it, right? While this is not a complete recitation of what I did, of all that I did or all that I know, it represents some of my conduct and some of my knowledge concerning my own illegal involvement in activity. No threats have been made against me, nor am I under influence of anything that could impede my ability to understand this proffer fully. Signed, Jacob. So, right, that's the critical part. And then also co-signed by his attorney, where he just says, I've read it, reviewed it, and discussed it with my client to make sure that he's getting counsel, right? Right. So that's why the attorney signs off. It's like, I've also read it, I've reviewed it, I've discussed it with my client. He's gotten my legal advice. So the client reads it, says, yes, all these facts are true. Jacob says all those facts are true. So all those things happened as far as the law is concerned. And as far as the law is concerned, all those things happen. So, you know, because he conceded. It's like he signs, he agrees. What more do you want? He did all those things. All right, so now let's read the plea agreement. Let's read the plea agreement as well, because that will be helpful in understanding law. Now, the reason I want to go through this in a little bit of detail is because a plea agreement is a contract. It's just a special kind of contract, right? It has a special name called a plea agreement, but it's a contract, right? And like any other contract, it's understood by its own terms and its own parameters. So what's in the contract matters. What's outside the contract doesn't matter, right? What matters is what's inside the contract, what's within the four corners of the contract, right? So when you're reviewing any contract, and this is no exception, you need to read it, understand it, and see what it does say and what it doesn't say, right? So let's see exactly what this contract says. What is exactly the nature of this plea agreement, right? It could say a whole bunch of things. It could potentially say any number of things, maybe infinitely many things, right? I mean, theoretically, there could be any nature of agreements, right? It could be a lot of different things. So, you know, hey, what did they agree to? Well, let's read it and see. All right. So this is addressed to Watkins, his attorney. This letter sets forth the full and complete plea offer, right? This plea offer expires on August the 13th. If your client accepts the terms and conditions, please have your client execute. Upon the execute document, this letter will become the plea agreement. The terms of the offer are as follows. So full and complete. Full and complete. Magic words to an attorney. Magic words to an attorney. Full and complete. This is all there is. There's nothing more. This is all the things. That's what full and complete means. This is it. This is everything. This is all the things. Okay, so your client agrees to plead guilty. They wrote count 1 and then struck it out, wrote 2, which is fine. And then they initialed the change. So initial the change. In the indictment, charge your client with obstruction of official proceeding. Your client understands that a violation of this carries a maximum sentence of 20 years, a fine of $250,000 or twice the pecuniary gain or loss of the offense, a term of supervised release of not more than 3 years, and an obligation to pay any applicable interest or penalties on fines. This is exactly the same language we saw in the recitation of facts. It's like, we're not trying to hide the ball. In addition, your client agrees to pay a special assessment of $100 to the clerk of the court. Don't ask me why. That's just $100. Your client understands that pursuant to law of the United States sentencing guidelines, the court may also impose a fine that's sufficient to pay the federal government the cost of any imprisonment, term of supervised release, and period of probation. So they can fine you as much as it will cost to imprison you and release you and probation. They can fine you for all those things. That's a thing that you're agreeing to. Further, your client understands that your client has 2 or more convictions for a crime of violence or felony drug offense. Your client may be subject to substantially higher penalties provided for in career offender statutes and provisions of the sentencing guidelines. Like, we're trying to make all the things. Your client agrees to the attached statement of offense, fairly and accurately describes your client's actions and involvement in the offense to which your client is pleading guilty. Please have your client sign it and return the statement of offense as a written proffer of evidence along with this agreement. In consideration of your plea of guilty, this is what we are offering. This is what we are offering. In consideration of your plea of guilty to the above, your client will not be prosecuted further by this office for conduct set forth in the attachment of the offense. The government will request the court dismiss the remaining counts of the indictment, in this case at the time of sentencing. Your client agrees and acknowledges the charges are to be dismissed at the time of sentencing were based in fact. So you're agreeing those charges are not part of a malicious prosecution. You're agreeing that those charges, even the ones we're dropping, are in fact based in fact. So they're not just something we're conjuring, right? That's part of the agreement. After entry of this plea of guilty to the offenses identified above, your client will not be charged with any nonviolent criminal offense in violation of federal or District of Columbia law, which was committed within the District of Columbia by your client prior to the execution of this agreement, and about which this office was made aware by your client prior to the agreement. So, however, the United States expressly reserves the right to prosecute your client for any crime of violence, if in fact your client committed or commits such acts prior to or after the execution of the agreement. I froze. It looks okay on my end. Drop frames. Did I just freeze for a second? It looks okay on my end. Stephanie said my camera froze for a second, but it looks okay on my end. Anyways. So yeah, you're agreeing to all those things. We agree not to charge you for any nonviolent offense that you committed. We agree to drop all these charges. We agree to not charge you for any conduct that occurred in this, but we will prosecute you for any other violent offenses that are distinct. All right, so here's the sentencing guideline, right? Your client understands the sentence in this case will be determined by the court pursuant to these factors, including a consideration of the sentencing guidelines. So the sentence is to be set by the court pursuant to the federal rules of criminal procedure and to assist the court in determining. The parties agree to the following. Right, so here's what you're agreeing to. The parties agree the following sentencing guidelines apply. Base offense level 14, and it goes to cite how that's calculated. Special offense characteristic, injury property, 8. Special offense characteristic, substantial interference, 3. Total is 25, right? So total is 25 for this level of offense, and you're agreeing to that. The government agrees that a 2-level reduction will be appropriate pursuant to law. Provide your client clearly demonstrates acceptance of responsibility to the satisfaction of the government through the allocution, adherence to every provision of the agreement, and conduct between the entry of the plea and imposition of the sentence. So we'll agree to drop it from 25 to 23 if you satisfy us as part of your allocation. They're not trying to trick you, incidentally, here. They're really not. They just want you to actually, you know, say exactly what you've already agreed to and not try to hide the ball. They're not trying to trick you here. It's like, yeah, if you are faithful to it, this is not a trick. They will definitely do it. Further, assuming your client has accepted responsibility as described, the government agrees that an additional 1 level will be appropriate pursuant to law because your client has assisted authorities by providing timely notice of your client's intention, thereby providing the government. So we'll provide you another drop down because you did this fast enough to save us the cost and time and expense of actually going to trial. So we'll drop it from 25 to 22. Nothing in this agreement limits the rights of the government to seek denial of adjustment for acceptance of responsibility and or imposition of adjustment for obstruction, regardless of any agreement, should your client move to withdraw the guilty plea after it's entered. So incidentally, that would be like now. So like, yeah. Or should it be determined by a government that clients either engage in conduct unknown to the government at the time that constitutes obstruction, or engage in additional criminal conduct after signing. So if you engage in additional conduct, that's before sentencing. So if you manage to commit more crimes between the time we reach this plea agreement and the time we reach sentencing, which is definitely a thing that sometimes happens. That's definitely sometimes the thing that happens. So if you commit more crimes in that interim, we're gonna yank that away. So in accordance with the above, we estimate it will be at least 22. So based on this information, your client has no criminal convictions. Accordingly, your client is estimated to have 0 criminal history points, and your client's criminal history category is estimated to be level 1. So in the sentencing guidelines, there's 2 axes. There's 2 axes, and each axis forms a little box. So you come up with a box grid, right? So one of the axes is how bad is this offense, and they calculate points in various ways by statute and regulations. So how bad is this offense? And then how bad of a criminal are you in general? Like how many bad things have you done? The idea being, of course, if you've done more criminal things in your past, then so far it hasn't dissuaded you. So maybe we need to punish you harder. So yeah, you determine how bad this offense is and how bad you are in the past. So you are level 22, 1, because you haven't done anything bad before. Okay, now here's the critical part. Right? Really critical part. Based on the offense level and the estimated criminal history category set forth, your client's estimated range is 41 to 51 months the estimated range. So the Department of Justice is telling you, they're not hiding the ball. They're not hiding the ball. They want you to be really clear about this so that they make sure that you know. And it's like, here's exactly what your offense is. Here's exactly how we calculated it. Here's the cross-references to how we calculated it. Here's exactly how it came about. Here's exactly why we're dropping it for exactly these reasons. Here's exactly what your criminal history score is because of exactly these reasons, right? We're not trying to hide the ball. And then they go on to say, well, based on that, the guidelines, which are not binding on the court, incidentally, they can go up or down from there, right? Because the guidelines are just a recommendation. They're a strong recommendation, but nevertheless. But they're not hiding the ball. They say 41 to 51 months. And he was convicted and sentenced to somewhere between 41 and 51 months. So how upset can you be, man? We told you exactly what you were facing, right? We didn't hide the ball. Pursuant to this, we also estimate the fine range at between $15,000 to $150,000. And your client reserves the right not to ask them not to impose a fine. So you can ask them not to impose the fine if you want. We don't care. That's fine. The parties agree that solely for the purpose of calculating the applicable range, neither a downward nor upward departure from the guidelines set forth above is warranted, except the government reserves the right to request an upward departure pursuant to some other section of law, which isn't going to be, consistent here. But they're still telling you. Except as provided for reservation of allocution, the parties also agree that neither party will seek an offense level calculation different from this. So the government says, we are agreeing that we will not seek any offense calculation other than this. This is the only one we'll seek. However, the parties are free to argue for criminal history category different from that estimated above, which doesn't really matter because he has no criminal history, so it doesn't matter. Your client understands and acknowledges the guideline calculated above is not binding on the probation officer or the court. Sentencing is for the court. Sentencing is for the court, for the judge. The Department of Justice doesn't control sentencing. They control what charges are being brought, but they don't control sentencing. So the Department of Justice, what they can do is make recommendations. And the defense team can make recommendations. And the judge can say, I like the prosecutor's recommendations. I like the defense recommendations. I should meet somewhere in the middle. I don't like either of them. They're both too high. I don't like either of them. They're both too low. Right? Any of those options. All those options. They're both too low. They're both too high. One's right. The other one's right. Somewhere in between. Anything. They're not binding on the court. They tell you to plead your case before the judge. They are not making this shit up. Should the court or probation officer determine the guideline range is different, that will not be a basis for withdrawal. So if the guidelines are wrong because the court determines a different level, sucks to be you. Your client understands the terms of this section apply only to conduct that occurred before the execution. Should your client commit any conduct after the execution that would form the basis for an increase in your offense level or justify an upward departure, for example, but not limited to obstruction of justice, failure to appear, criminal conduct, and false statements, the government's free to seek an increase. So if you commit more crimes, we have the right to seek an upward departure, because that definitely is a thing that happens. The parties further agree sentencing within the guidelines range would constitute a reasonable sentence in light of all the factors. Should such a sentence be subject to appellate review notwithstanding the appeal waiver? So you're agreeing that this is reasonable if you appeal, despite the fact that you're not allowed to appeal because you waived your appeal. However, the parties agree either party may seek a variance and suggest the court consider sentencing outside the guideline range based on factors. So, you can ask for sentencing beyond the guidelines, right? The U.S. government didn't even promise to recommend a sentence within the guidelines, if you take notice. They said they wouldn't contest the guideline number. They said they wouldn't contest the guideline category. They said they wouldn't contest the fact that this was offense level 22. They said they wouldn't contest the fact that this was criminal history 1. But they never at any point said, we're agreeing to recommend a sentence. They never said that. This is why it's important to read the words very carefully, like a lawyer, and what it does and does not agree to. Like, the Department of Justice agrees that these are the guidelines. But, you know, what that says is either party can seek a variance outside the guidelines, which is a thing the court can do, right? So this is the guideline penalty, but if we want to get up there and say, you know, we don't think 41 to 50, whatever it was, is enough. We want, how about 70? And you're like, wait, what? Like, well, we agree that the sentencing guidelines are this. We just don't think they're adequate. We want 70. You can't be sad because they never promised to recommend a particular sentence. They didn't promise to recommend it. That's exactly what that says. Pay attention. The words matter, man. Okay, the government and your client reserve the right to describe fully, both orally and in writing, to the sentencing judge, the nature and seriousness of the misconduct, including any misconduct not described in the charges, for which your client is pleading guilty, to inform the pre-sentence report writer and the court of any relevant facts, to dispute any factual inaccuracies in the pre-sentencing report, and contest any matters not provided for in this agreement. The parties also reserve the right to address the correctness of any sentencing guideline calculations determined by the pre-sentencing writer or court, even if those calculations differ from those above, right? So if the guy who does the pre-sentencing report, which is an independent person that works for the judicial system, they're also going to do a pre-sentencing guideline calculation. So the Department of Justice says, well, we think it's 22-1. We're agreeing to that. But if for any reason this other guy comes up with a different number, we have the right to contest that. Not for least reasons, we agreed to 22-1. So, you know, in the event the court or the pre-sentencing writer considers any sentencing guidelines, adjustments, departure, or calculations different, or contemplates a sentence outside the range based upon factors, the parties reserve the right to answer any related inquiries from the court or the pre-sentencing writer and to allocate for a sentence within the guideline range, or as ultimately determined by the court, even if the guideline range ultimately determined by the court is different from that range. So it's like, you know, pay attention to what you're agreeing to, man. The fine details matter. In addition, if the agreements the parties have agreed to recommend or refrain from recommending to the court any particular resolution, the parties reserve the right to full allocution in any post-sentencing litigation. The parties retain the right of full allocution in connection with any motion which may be filed in this matter before the Bureau of Prisons. Your client acknowledges the government is not obligated to and does not intend to file any post-sentencing downward departure motion. Because, you know, we could file for a post-sentencing downward departure, but we're definitely not going to do that. And then, again, we're just going to remind you of the critical details here. Make sure you're paying attention. Court not bound by this agreement or sentencing guidelines. Your client understands the sentence in this case will be imposed in accordance with the statute upon consideration of the guidelines. Your client further understands the sentence to be imposed is a matter solely within the discretion of the court. Pay attention. Your client acknowledges the court is not obligated to follow any recommendations of the government at the time of sentencing. Your client understands that neither the government's recommendation nor the sentencing guidelines are binding on the court. They sure aren't. Your client acknowledges that your client's entry of guilty plea to the charged offenses authorizes the court to impose any sentence up to and including the statutory maximum, which may be greater than the range. In this case, it'll be a lot greater than the range, but that's a possibility. The government cannot and does not make any proper promise or representation as to what sentence your client will receive. Moreover, it's understood your client will have no right to withdraw your client's plea of guilty should the court impose a sentencing that's outside the range. So you are agreeing to plead guilty, and this is the range, but if the court decides to dick you over, you know, you are agreeing that you can't withdraw your guilty plea just because they decide to dick you over. You know, so pay attention. The words matter on the page. The government and your client will be bound by this agreement, regardless of sentence imposed by the court. Any effort by your client to withdraw this plea of guilty because of the length of the sentence shall be constituted a breach of this agreement, which, you know, they're in breach of the agreement. Your client agrees not to object to the government's recommendation to the court at the time of plea of guilty, that your client be detained without bond pending sentencing. And so then there's a whole bunch of waivers. Your client agrees to waives any challenge of venue. I mean, it is the appropriate venue, but just for the hell of it, let's agree to waive that anyway. The statute of limitations, this is a fun one. Your client agrees that should the conviction for the plea of guilty be vacated for any reason, any prosecution based on the set offense is not time barred by statute. It is the intent of this agreement to waive all defenses based on statute of limitations with respect to any prosecution of conduct set forth in the attachment statement of offense that's not time barred. So if, for any reason, this becomes vacated at some point in the future, you can't argue, hey, wait a second, you can't put me on trial again because that's outside the statute of limitations. No, you just waive the statute of limitations. What statute of limitations? It doesn't apply to you, man. That's what you're agreeing to. Read the words on the page. Your client understands by pleading guilty, you agree to waive certain rights afforded by the Constitution and or statute or rule. Your client agrees to forego the right to any future discovery or disclosures of information not already provided at this time. Your client agrees to waive, among other rights, the right to plead not guilty and the right to a jury trial. If there was a jury trial, your client would have the right to be represented by counsel. Again, this is just to inform you of your basic rights. The judge is going to do this too. But the U.S. attorney is absolutely smart to put this in here, right? Just to remind you, these are your rights. And the judge is going to do this too. Just to remind you, these are your rights, right? So it's like, just to remind you all the things you're giving up. If there were a jury, your client would have the right to be represented by clients, to confront and cross-examine witnesses, to challenge the admissibility of evidence, to compel witnesses to appear. If there was a trial jury and your client does not choose to testify, your client would have the right to have the jury instructed that failure to testify could not be held against the client. Your client would further have the right to have the jury instructed that your client is presumed innocent until proven guilty, and the burden of proof would be on the state to prove guilt beyond a reasonable doubt. If your client was found guilty after trial, your client would have the right to appeal this conviction. You understand that the Fifth Amendment to the Constitution protects your client from the use of self-incriminating statements in a criminal prosecution. If you keep your mouth shut, sure. By entering this plea of guilty, you knowingly and voluntarily waive or give up your right against self-incrimination. You're definitely incriminating yourself because you're agreeing to all those pesky facts. Your client acknowledges discussing with you Rule 11 of the Federal Rules of Procedure and Rule 410 of the procedure, which ordinarily limit admissibility of statements made by defendant in the course of plea agreements. So that's a really big deal. That's a really big deal. So let me tell you what that says. All right. So any statements you make during the plea negotiation process cannot be used by you in court unless you take the stand, and then they can be used as character evidence. I mean, if you say something false or inconsistent, right? But if you don't bring it up, so if you say things during the course of plea negotiations, and you want a lawyer for this, right? So you can't just go, hey, prosecutor, by the way, blah blah blah, right? So there's parameters. But anything you say during those plea negotiations can't be used against you in court. If you say something completely inconsistent with that on the stand, then they can challenge your credibility. But if you never say anything inconsistent, whether you repeat that stuff or not, right? They can't bring it up. So during cross-examination, they can't bring it up. Anything they learned from that process. So if they learned it from somewhere else, they can ask you about it. Right? But if the only way they had that knowledge was from that plea negotiation, they can't bring it up. Negotiation conferences are secret. They're privileged, if you like. Privileged is not quite the right word, but they're confidential. They can't be used against you. So that's what that says. Hey, you might have made a whole bunch of representations, to us during the plea negotiation process. If in the end of the day you tell us to buzz off, there are rules, man. We can't use that shit against you. Okay? So you acknowledge discussing this rule, which ordinarily limits the admissibility of statements that are made in the course of those plea negotiations. Your client knowingly and voluntarily waives right that arise from this rule in the event your client later withdraws the plea of guilty or withdraws from this agreement. So one of the things we're agreeing to is, hey, wait a second, there's a rule that says specifically we can't use this against you in trial, but we're making a plea agreement, so we can agree to pretty much anything, right? So one of the things you're agreeing to is like, if you told us anything during those plea negotiation conferences, you know, and you attempt to withdraw or you attempt to modify this, now we're able to bring all that back in. Now we're able to bring it back then. So you're agreeing to waive that if you try to withdraw. So to the extent you said anything that would further damn you, we can bring that up. You also agree to waive all constitutional rights to a speedy sentence, which is not really a right, but whatever. And it agrees to a plea of guilty pursuant to this agreement will be entered at a time decided upon the parties with concurrence of the court. You understand the date for sentencing will be determined by the court. Is it uncommon to use parallel construction to get that information? Well, probably not. Probably not, but you have to be very careful about how you do that so you don't get burned. But yeah, once you know, you might be able to put it together, but you have to be very, very careful about that. So just, yeah, you might, yeah. But as I say, it doesn't apply to anything you learned otherwise. So if they come and tell you everything you are, if they come and tell you nothing new, right? So it doesn't matter, right? So it only matters if they tell you something new. So your client agrees to waive insofar as waivers permitted the right to appeal. So you're agreeing to waive appeal. Included but not limited to the claims that the statute to which your client is pleading is unconstitutional. Can't argue that. The admitted conduct does not fall within the scope of the statute. Can't argue that. Your client understands federal law affords the defendant the right to appeal their sentence in certain circumstances. Your client agrees to waive the right to appeal the sentence, including but not limited to any term of imprisonment, fine, forfeiture, award of restitution, term or condition of a release, authority of the court to set release, and any manner in which the sentence was determined, except to the extent your court sentences you above the statutory guidelines, or except to the extent the court sentences you above the statutory maximum, or above the guidelines range determined by the court. So if they go above the guidelines range, you don't have the right to withdraw your plea of guilty, but you can appeal the sentence. So, you know, and you obviously can appeal if they sentence you to more than the statute allows, because obviously they can't do that. Realizing the uncertainty in which estimating the sentence will ultimately impose, your client knowingly and willingly waives the right to appeal the sentence to the extent noted above in exchange for concessions made by the government. Notwithstanding the above agreement, your client retains the right to appeal on the basis of ineffective assistance of counsel, but not to raise other issues regarding conviction and sentence. So that's basically your only track left, and probably the track that Pierce is going for, right? It's like you don't waive, that would be a little bit hard to like waive the ineffective assistance of counsel, because it's the counsel themselves that would be reading and signing this off. So if they're ineffective, you don't agree to that. But let me just tell you, ineffective assistance of counsel is really hard. As I'm sure we've discussed on the channel before, that's a really hard thing. You basically have to show that this guy is truly incompetent. And that's really, really hard. That's really, really hard to show this lawyer is truly incompetent or did something that no reasonable lawyer would do. And lawyers get a lot of latitude for doing stuff because there are tactical and strategic concerns. So a lawyer might do something that might make another lawyer scratch their head, but from within their own frame of reference makes sense because of various tactical considerations. Those tactical considerations may or may not pan out at the end of the day, which is one of the reasons that it makes the other lawyers scratch their head, because we're like, oh, we're not so sure about that one. And then it doesn't pan out. But yeah, you get a lot of latitude as a lawyer. So you have to do something basically no other reasonable attorney would do. You have to fail to look at particular lines of defense, or, you know, blatantly ignore, you know, stuff. It's pretty damn hard. So if you're going to appeal on ineffective assistance of counsel, all I can say is Godspeed, sir, because that's probably not going to end up well. Your client also agrees to waive any challenge to the conviction imposed by the agreement, or otherwise attempt to modify the agreement in which by collateral attack, including by admission to habeas, except to the extent of motions based on newly discovered evidence or on a claim your client received ineffective assistance counsel. Your client reserves the right to file a motion brought by 3582, but waives the right to appeal for denial of that motion. The government agrees pursuant to law that the self-incriminating information provided by your client pursuant to this agreement during the course of the debriefings in anticipation of the agreement, and about which the government had no prior knowledge, or insufficient proof in the absence of admission, will not be used by the government at the time of sentencing. So any statements you made during the plea negotiations, we won't use against you, but it may be used for purposes in accordance with terms as we've noted above. Client, your restitution, client acknowledges a riot occurred, caused approximately $1,495,326.55 of damage. Your client agrees to a part of the deal to pay restitution in the amount of $2,000. Payment shall be made to the court in order to facilitate collection, blah, 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 blah. Your client understands that after entering this agreement, your client fails to perform any event, that's breach. In the event of the breach, government will be free from its obligations. Your client will not have the right to withdraw the guilty plea. Your client will be subject to full criminal prosecution for any other crimes, including perjury and obstruction. Government will be free to use against your client directly and indirectly in any civil or criminal proceeding all statements made by your client and any information or materials received by your client, including such statement, information, materials provided pursuant to this agreement or during any course of debriefing. That's all the things, basically, whether or not any debriefings were previously characterized as off the record. So, you know, if you breach this agreement, all that goes bye-bye. Your client understands government shall be required to prove breach only by preponderance of the evidence. So only by 51%, because remember, a plea negotiation is a contract. Remember, I think I told you that earlier, right? A plea negotiation is a contract. It's just a special kind of contract. It's a special kind of contract. And so contracts are typically, you know, the civil standard. It's the civil standard for contracts, right? 51%. So it's no different here. Like, the government only has to prove breach by 51%, not beyond a reasonable doubt, because we're basically interpreting it using the civil standard because it's a contract like any other contract. It's just for special and unique things. Nothing in this agreement shall be constituted to permit your client to commit perjury, to make false statement or declarations, to obstruct justice, or protect your client from prosecution for any crimes not included with the agreement or committed after execution. You'll understand the government reserves the right to prosecute your client for such offenses. You further understand that any perjury, false statement, obstruction relating to obligations shall be constituted a breach. In the event of the breach, your client will not be allowed to withdraw. And then this is the other major part. This is the other major part of basically every contract. Every contract has a provision like this, and plea agreements are no exception. So this is the part, like, you really want to pay attention to, and you want to really make sure you understand all these words, right? This is an important part of contracts. Complete agreement. Complete agreement. No agreements, promises, understandings, or representations have been made by the parties or their counsel other than those contained in the writing herein. Nor will any such agreements, promises, understandings, or representations be made unless committed to writing and signed by your client, defense counsel, and the assistant attorney general. So that's the big deal, right? So pay close attention. If it's not within the four corners of this document, it does not exist. You cannot go and say, hey, wait a second, you said this at that meeting, or you said that at this meeting, or you made this promise, or the detective made that promise, or whatever, right? You said this, or my clients or my lawyer said that. No, everything's in this document. If it is not in the document, it does not exist. That's what it means by a complete agreement. All that exists is this contract, nothing more. There is nothing outside the contract. It does not exist. If it's not here, it doesn't exist. So all those other promises, to the extent they exist, poof. Because that's what complete agreement means, man. Everything is here. Your client further understands this agreement is binding only upon the criminal and superior court divisions of the United States Attorney for the District of Columbia. This agreement does not bind the civil division of this office, so we can sue you, or any other United States Attorney's office. So if there's somehow some other prosecution that could be made by some other attorney's office, it doesn't bind them, nor does it bind any state, local, or federal prosecutor. So to the extent that, you know, a state or locality, which isn't applicable here because DC is federal, so this doesn't really apply, but, you know, still. It also doesn't bar or comprise any civil, tax, or administrative claim. So if there's those and the foregoing are compliant, then you can sign by the assistant attorney general, or signed by the assistant attorney, signed by the assistant attorney, and defendant's acceptance. I've read every page of this agreement and discussed it with my attorney, Albert Watkins. I fully understand this agreement and agree to it without reservation. I do this voluntarily and of my own free will, intending to be legally bound. No threats have been made to me, nor am I under the influence of anything that could impede my ability to understand this agreement fully. I am pleading guilty because I am, in fact, guilty of the offenses identified in this agreement. I reaffirm that absolutely no promises, agreements, understandings, or conditions have been made or entered into connection with my decision to plead guilty except those set forth. There is nothing more, only this. I am satisfied with the legal services provided by my attorney. I am satisfied with the legal services provided by my attorney. Yeah. In connection with this agreement and matters related to it. So at least at the date I signed this, I was totally satisfied. Now I'm less satisfied. And then the attorney acknowledges that I've discussed it and, you know, concur in the blah, 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 whatever. So yeah, that's a lot of stuff, man. That's a lot of stuff. So yeah, the long and short of it is that the overwhelming odds are that Shaman Guy is going to be spending some quality time in a federal prison for the next 3 years and change. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.